Item for delivery of judgment. Number 42, WPC 4498/2024, and item 43, 4628 of 2023.
WPC number 4498/2024 stands allowed.
Masuk.
And WPC number 4628/2023 is partly allowed.
May it please your lordship. Lordship, I beg to mention item number 18. I'm for the petitioner. Respondent 4 expired. So we need to file a substitution petition, lordship.
You are for the
Petitioner.
item number 18.
18, IA. IA 3168.
Okay.
Orders column.
Your name?
D. Pathak.
Ms. D. Pathak, learned counsel for the applicant. With consent from the other side, press for listing the matter after?
After 3 weeks, lord.
After 3 weeks. Fair allowed.
Highly obliged.
Item number 4 and 5. Can you be on a hearing them around 4?
Fourth.
Then
Any hearing date, lordship?
4 or 9, 12.
9. Okay, 9.
That is-
As agreed by.
Petition of UGC. UGC is not.
On that day, we will
Yes,
consider.
Lordship will consider, because we feel that my lord UGC is the main authority, will have to clarify whether the NOC is required or not. From the
Technical Institute AICTE will govern.
that
Okay.
Lordship will consider on that.
On next day, we will consider. As
Lordship,
agreed by
it-
learned
it-
advocates
it
of
may
both
be
the
declared-
parties, recess shall list the matter on 9th of June.
remain as part of
It
lordship.
is
As part of, okay.
Ninth lordship.
Lordship, item number 15, your lordship. This honorable court has directed me to take the steps, and we had taken the steps and that had not been reflected. So I may be allowed to 3 weeks time to file fresh petition to the sole respondent. Steps to be taken to the sole respondent.
Press step.
We had
After-
taken steps that have been defected, that have not shown in the here. So I have to rectify and clear the matter.
Okay, on the pair being made by Mr. B.N. Gogoi, learned counsel for the appellant, recess shall list the matter on after
3 weeks here.
after 3 weeks.
And
Fair allowed.
developed.
May it please, Lordship.
Hmm.
Lordship, so with due concern on the other side, I beg to mention item number 2, Lordship.
Hmm.
Lordship, this matter can maybe taken up in the next week, Lordship. We have some personal difficulty, Lordship.
Lordship,
Taking the consent of the other side.
Lordship, if possible, Lordship, the second main Lordship is the authorized Lordship, the part of matter Lordship.
2nd May.
Second main Lordship,
Oh, no, sorry, 2nd June.
the long pending matter Lordship.
Thursday, ma'am. Thursday,
On?
Thursday, ma'am. Thursday.
No, this is a admission matter,
Yes, Lordship, is it
not on hearing
That
date.
Wednesday, ma'am.
Wednesday. Okay. As agreed by learned advocates of both the parties, recess shall list the matter on 3rd of June.
Yes. Masuk.
Your lordship, I would like to mention an item for listing, your lordship, miscellaneous first appeal. Your
What
lordship.
matter?
Miscellaneous first appeal, MFA.
Okay.
Next
When
week,
do you
your
want?
lordship. The matter has been pending since your lordship 2024.
When do you want?
Next week, any date, your lordship.
Take a date from him. Yes.
May it please your lordship. Your lordship, I beg to mention for listing of an IA, your lordship.
IA.
Yes, your lordship.
When?
IA. Lordship, any date.
In which matter?
Your lordship, MAC appeal matter.
Mat appeal.
IA was
Okay.
filed for praying for condemnation of delay, your lordship.
Okay, when do you want?
Your lordship, the matter has not been listed till now, your lordship.
Yes, when do you want the matter to be listed?
Lordship, first week of June, your lordship.
On
First week of June,
1st week of June.
your lordship.
Okay.
5th June. 5th June.
Your lordship.
For listing, my lord.
Hmm.
One, my lord, MSC appeal, my lord, hearing matters, my lord.
Hmm.
For listing, my lord.
When?
My lord, on 18th of June, my lord. And earlier, when it obliged, my lord. Another, my lord, it's admission matter,
Hmm.
same MSC appeal, my lord. Same day, my lord, also. Obliged.
22nd.
Hmm.
On 22nd.
Obliged.
Item for motion, item 1.
Lord, this honorable court had passed an order, my lord, on
10/4/24 at page 28, whereby at page 29, this Honorable Court had directed the petitioner to appear on or before 13/5/24, para 6, my lord, for applying for regular bail. That period had got over, my lord. Para page 29, my lord.
No, thereafter what happened?
But thereafter, my lord, for medical reasons, he couldn't appear. But my lord, if my lord may kindly see page 26, my lord, he has already been, his statement was recorded, and in the charge sheet, it has seen that the case is ready for trial, my lord. He is ready and willing to appear before the trial court, my lord. But the only thing is that he may be granted the protection till the next date is on 24th of June, my lord. He will appear before that honorable court, my lord. When this application was filed, last date was on 16th of May. Now it is on 24th of June, my lord. So there's a bona fide apprehension, my lord, that he may be arrested, my lord. So that is the reason why, my lord, because the period had got over, my lord. At page 29, he was asked to appear on or before 13/5/24 and seek for regular bail.
No, you have not complied with the direction issued by this court.
So that is the reason why
What is the bona fide ground? What is
my
the
medical
bona fide
reasons are
reason?
submitted, my lord. Para 8, my lord.
Hmm?
Para 8 and 9, my lord.
You go and file an application before the trial court.
Till such time I may be protected, my lord. I will appear, my lord. Moreover,
No,
my lord,
no.
the para page 26.
Such an interim protection was earlier granted to
Because
you.
that has elapsed, so that is the reason why. I will appear, definitely appear, my lord.
No.
I'll definitely appear, my lord. Moreover, my lord, page 26 may kindly be seen, the second last paragraph, my lord, that I have also been interrogated by the police, my lord. And my statement has also been recorded, my lord. Page 26, second last paragraph.
You go and show all these documents to the learned trial court. Trial court will consider the same.
Till then, my lord.
You see, since 13/5/2024, almost 2 years elapsed.
2 years.
So
Had it been immediately after
that is
this
true.
date,
That is true.
then we would have considered it.
That is true, my lord. That is true.
Now, where is the scope?
That is true. But till then, my lord.
No. Heard Mr. Kaun, learned counsel for the applicant, then Mr. B. Sharma, learned additional PP for the state respondent. This application under section 438 of the 482 of the BNSS 2023 is preferred by the applicant, namely Azmat Ali alias Azmat Ali alias Azmat Ali, who has been apprehending arrest in connection with Gauhati PS case number 309 of 2023, registered under section 379 411 34 IPC, read with section 13 within bracket 1 of the Assam Cattle Trespass Act, for grant of PS bail. Notably, Gauhati PS case number so and so has been registered on the basis of one FIR lodged by one Shiva Prasad Kolita on 25/8/2023. Full stop. The allegation against the present present applicant is that, acting on a tip of, the police personnel conducted raid in the house of the present applicant and recovered carcasses of 2 cows and seized the same in presence of witnesses and apprehended one Ashraf Alam. And during interrogation, it has come to light that the present applicant along with Ashraf Alam used to commit theft of cow from the different places and running the illegal business of slaughtering the cows. Mr. Khan, learned counsel for the applicant, submits that the applicant has preferred one application under section 438 of the Code of Civil Procedure, which was registered as AB number 3152 of 2023, and the same was disposed of by order dated 10/4/2024, directing the applicant to appear before the learned trial court on or before 13/5/2024 and to apply for regular bail. And in the event of filing such an application, the direction was issued to the learned trial court to consider the same in accordance with law. Mr. Khan further submits that due to some inconvenience, the applicant could not appear before the learned trial court, and that in the meantime, investigation of the case has been completed, and the petitioner has also appeared before the IO and his statement was recorded, and he is ready to face trial. However, he apprehends that if he surrenders, apprehends that in the event of his appearance before the learned trial court, he may be arrested, and therefore he has contended to grant the privilege of PRS bail to the applicant till the date of his appearance before the learned trial court. However, Mr. B. Sharma, learned additional PP, has opposed the application, and he pointed out that about 2 years back, the applicant was directed to appear before the learned trial court, and he failed to appear before the learned trial court. And in the meantime, investigation has already been completed and search sheet has been submitted before the learned trial court. And there is no scope, no ground for granting him the privilege of PRS bail at this stage, and therefore he has contended to dismiss the petition. But having heard the submission of learned counsel for both the parties, this court has carefully gone through the petition and the documents placed in record. It appears that investigation of the case has already been completed, and the IO has filed search sheet, being search sheet number 347 of 2023 on 38/11/2023. And the next date is fixed on
24/6/2026.
24/6.
24/6.
24/6/2026. 2026. It appears that the applicant was already granted the privilege of interim protection by order dated 4/10/2023. And thereafter he appeared before the IO and his statement was recorded. And thereafter the interim order dated 4/10/2023 was made absolute.
Not made actually, madam, on the third sheet on the this, terminated that, third sheet submitted, madam. Then it was notified, paragraph 7/6, madam.
And in the meantime, in view of the submission of charge the said interim order was not made absolute, but direction was issued to the applicant to appear before the learned trial court and to apply for regular bail. And till then, interim order dated 4/10/2023 stands extended.
Extended after 13/5. Paragraph 6, madam.
Hmm.
Please continue.
And further, it appears that since 13/5/2025, 2024, more than 2 years elapsed. But the applicant failed to appear before the learned trial court. And under the given facts and circumstances, this court find this application devoid of merit and accordingly the same instance dismissed. The applicant is directed to appear before the learned trial court with a prayer for granting regular bail, and in the event of filing such an application, the learned trial court shall consider the same in accordance with law.
Much.
Items for orders, item number 16.
May I please your lordship? As per office note dated 7/2026, service report of respondent number 2 has not received yet.
Heard, Miss,
P. Sharma.
learned counsel for the appellant. Office note dated 7/3/2026
2026.
indicates that service report in respect of respondent number 2 is still awaited. Accordingly, taking note of the aforesaid office note, it is provided that the appellant shall take fresh sleep upon respondent number 2 within a period of
Right.
1 week from today by speed post and also by usual process. List after 4 weeks. Fresh sleep.
Item 17.
Absent.
Yes, your lordship has recorded in the last order that again, they are absent and appropriate steps will be taken. So I pray that some order may be passed, that they are not appearing.
None appears for the applicant on call. How about Mr.
See, go ahead.
C. Gogoi, learned counsel?
17 and 16, this was
Get in.
one from little game. Okay.
Okay.
Thank you.
Actually, the counsel for the applicant has filed one application for VC. But
We are not allowed to waive.
Then your lordship, one more opportunity.
one more, yes. However, Mr. C. Gogoi, learned counsel for the respondent, present. Leaves the matter after 1 week in the event of subsequent non-representation of the applicant, appropriate order shall follow.
Item 19. May I please, your lordship? I was busy with another item, that item was one. My item is 7, my lord. 7 is not.
This is 19.
Okay. Oh. Item 19.
But I'm for the appellant, but ECR has been received, my lord.
Matter is ready for hearing.
Otherwise, you say appeal admitted lordship. And let's say also repeat lordship.
No, matter is ready for hearing. Heard, Mr.
As Banikya,
S. Bonikya, learned counsel for the
appellant.
appellant, and Ms. P. Bhattacharya, learned counsel for the respondent. It is submitted at the bar that this matter is ready for hearing. Accordingly, it is provided that recessal list the matter for hearing.
Some date because this is regarding the permanent lordship. I for the wife lordship. After this, take lordship.
21st.
Item 20.
Service may be awaited in respect of respondent number 2.
Others completed.
That's lordship,
Completed.
service completed.
Heard, Mr. Bhatt, learned counsel for the appellant.
As per office note dated 22/5.
Office note dated 22nd May 2026 indicates that neither ID card nor unserved notice issued to the respondent number 2 received back by the registry till date. Leaves the matter after 2 weeks awaiting service report upon respondent number 2.
21.
It is the lordship. I had filed a delay condemnation petition for filing a review loss.
Filing a
Review is a delay condemnation in review petition. So service on respondent number 3 is not complete. But then lordship, he is the claimant and the owner's service is also complete lordship. Delay can be condoned and driver can be struck off also. Respondent number 3 is the driver.
heard Mr. Goswami, learned counsel for the applicant, and also heard Mr.
DK Kolita, respondent number 1.
D.K. Kolita, learned counsel for the respondent number 1. Mr. Goswami, learned counsel for the applicant, submits that the name of respondent opposite party number
3 lordship.
3,
Yes, lordship.
who is the driver of the offending vehicle,
Yes, lordship.
may be struck off from the area of this application. Accordingly, taking note of the submission of Mr. Goswami, learned counsel for the applicant, the name of respondent number 3, respondent opposite party number 3 be struck off from the area of this application at the cost and risks of the applicant. Any objection in condoning the delay?
No, lordship.
No.
No.
Mr. Goswami submits that this application is filed under Section 5 of the Limitation Act 1963 for condonation of delay of 60 days in preferring the review petition. Mr. Goswami submits that the order, when it was passed, order was passed. That's-
Lordship was passed on 12/1/2024.
Mr. Goswami submits that the judgment was passed by this court in MSC Appeal number 285 of 2013 on 12/1/2024. And the review application could not be filed in time What is the reason?
Reason, Lordship, I have given para number 2, Lordship.
Yes, after the judgment being passed by this court on 28/1/2024, the judgment was transmitted to the Kolkata office of the applicant on 31st of January 2024. And there was delay in obtaining opinion. And thereafter, review petition was prepared and also forwarded to the Kolkata office. And in the meantime, 60 days
Yes, Lordship.
elapsed. And the same was not intentional, and rather it was circumstantial. And that the applicant has a good case in appeal, and therefore it is contended to condemn the same and to admit the appeal. The learned counsel for the respondent number 1 submits that he has no objection in the event of condemnation of delay of 60 days in preparing the connected review petition. Error. Having heard the submission of learned counsel for both the parties, this court has carefully gone through the application and the documents placed on record and also the explanation put forwarded for the delay of 60 days in paragraph number 2 of the application. Accordingly, taking note of the submission of learned counsel for both the parties and also considering the explanation so put forwarded, this court is of the view that the delay is sufficiently explained and accordingly the same is thence condemned. And in view of the order passed in the IA number 1298 of 2024, the registry shall register the review petition and list the same before the court as soon as practicable.
Obliged, Lordship.
Rightly, your lordship.
Hmm.
My lord, this IA, my lord, is for condoning delay, my lord. Delay of 136 days, my lord.
Yes, any objection?
No, respondent number 1 to 8.
Basically on
Mr. Kolita, learned counsel for the applicant, and Mr.
A.N. Iqbal on behalf of N.I. Chaudhary.
learned counsel appearing on behalf of Mr. N.I. Chaudhary for the respondent number 1 to 8.
1 to 8.
1 to 8. This application under section 5 of the Limitation Act 1963, read with section 173, is preferred by the applicant for condonation of delay of 139 days in preferring connected MSc appeal against the judgment and award dated 29/8/2023 passed by the learned member, Motor Accident Claim Tribunal number 3, Kamrup M. Gauhati in MSc case number 1767 of 2017. Mr. Kolita, learned counsel for the applicant, submits that the judgment and award, impugned judgment and award was passed on 29/8/2023 and thereafter. What is the reason?
My lord, lordship may kindly see paragraph 3. Lordship, I have annexed the legal opinion of the dealing counsel, my lord. And the opinion reflects that the file with him in the chamber was misplaced. That is why he rendered the legal opinion very lately, my lord. That is his, I have annexed the legal opinion as well, my lord. It is annexed one.
Referring to paragraph number 3 of the application submits that after the judgment and award being passed by the learned tribunal, the same was forwarded to the dealing advocate of the applicant. And the said dealing advocate has misplaced the file, and therefore he could not file the opinion in time. And on account of the same, the appeal could not be deferred in time. And the delay is not intentional, then the same has been duly been explained, and therefore it is contended to condemn the same. The learned counsel for the respondent opposite party submits that he has no objection in the event of condemnation of the aforementioned delay. Accordingly, taking note of the submission of learned counsel for both the parties and also considering the explanation so put forwarded by the applicant, this court is of the view that the delay of
136, my lord.
136 days stands sufficiently explained, and accordingly the same stands condemned. In terms of this IA stands disposed of, and in view of the IA or order passed in the IA, now the registrar shall proceed to register the MSc appeal and list the same before the court as soon as practicable. The filing number, no?
Item 23.
Highly obliged.
Lordship, 9 days delay in preparing appeal. But as per office note, notice on respondent number 2 and 1 and 2 has not, 2 and 3 has not been returned. As per Lordship, the postal remark dated 25/2021. But appeal is on quantum. I think claimant also no objection. It will be benefit for the claimant for set for admission next week. Lordship, 9 days delay on quantum.
Any objection?
No objection.
Heard Mr. Goswami, learned counsel for the applicant, and Mr.
Iqbal on behalf of NI.
Iqbal, learned counsel appearing on behalf of Mr.
NI Chaudhary.
N.I. Chaudhary, learned counsel for the respondent, opposite party number
1.
1. Mr. Goswami, referring to the office note dated 25/5/2026,
26.
submits that service in respect of respondent number 2 and 3 are yet to be completed. But he pointed it out that the appeal is preferred against the quantum, and as such, the respondent opposite party number 1 may not have any objection, and service of notice upon the other two respondents or respondent opposite party are also not required, and therefore he has contended to condemn the delay of 9 days. And what is the ground?
Ground we have stated in paragraph number 4 and 5, Lordship.
What is the ground?
Lordship, the after taking opinion, the approval of the for filing appeal was taken time, Lordship.
And he further submits that the legal opinion could not be obtained in time, and the delay is not intentional, and therefore he is contended to allow this application and to condemn the delay of 9 days and to admit the appeal for hearing. The learned counsel for the respondent opposite party number 1 submits that he has no objection. Accordingly, taking note of the submission of learned counsel for both the parties and also considering the explanation so forthcoming for the delay of 9 days, this court is of the view that the same is sufficiently explained, and accordingly the same stands condemned. In view of the order passed in this IA, registry shall proceed to register the appeal and list the same before the court as soon as practicable.
Showing the name of the counsel also, but otherwise he will not get the information.
Okay, Mr. Goswami, learned counsel for the applicant submits that the name of the learned counsel for the
Respondent number one.
respondent number one may be reflected in the cause list. Rest shall do the needful in this regard.
Obliged, Your Worship.
Item 24.
Wait, Your Lordship. Sure, I'm sorry, I could not go through the case record, whether service is complete or not.
Third, Mr. Loskor, learned counsel for the applicant. Office note dated 19/5/2026 indicates that service in respect of respondent number 3, service report in respect of respondent number 3 received from the process server with a report that the respondent number 3 is out of station and therefore notice could not be served. And the said office note also indicates that neither ID card nor unserved notice in respect of respondent number 1 and 2 received back by the registry. Accordingly, it is provided that the applicant shall take fresh step upon the respondent number 3, and registry shall list the matter after 4 weeks, awaiting service report upon respondent number 1 and 2. Step upon respondent number 3 be taken by speed post and also by usual process within a week from today,
By way of speed
after
post,
4 weeks.
Lordship, by way of speed post,
Yes, both the way.
both the way. Obliged.
Item 25.
May it please your lordship? Your lordship may peruse office note dated 12/3/2026. Your lordship, as per postal track consignment, notices were duly served to respondent number 2 and 3, your lordship.
Third, Ms. Borthakur, learned counsel for the applicant, and Mr. Kolita for respondent number.
Your lordship, as per office note dated 24/2/2026, respondent number 1 has expired, your lordship.
Yes, expired, Lordship, I have to substitute.
We have to file
For the
substitution.
respondent number 1. For the respondent number 1. Ms. Borthakur, learned counsel for the appellant, referring to office note dated 24/2/2026, submits that the respondent number 1 suffered demise, and a report to that effect has been received by the registry and available on the record. And Mr. Kolita, learned counsel, who entered appearance on behalf of respondent number 1, submits that now the appellant has to take step for substitution of the legal heirs of the respondent number 1. Ms. Borthakur submits that she will take necessary step within a period of 1 week from today,
Your lordship, we have to get the names of legal heirs of respondent number 1, your lordship.
after
3 weeks, your lordship.
after 3 weeks. After 3 weeks. The office note dated 12/3/2026 indicates that as per postal tracking report, notice upon respondent number 2 and 3 have been delivered, but no one entered appearance on behalf of the respondent number 2 and 3. In view of above, notice upon respondent number 2 and 3 deemed to have been served. Mr. Kolita, learned counsel for the respondent number who appeared on behalf of the respondent number 1, shall furnish the name and address of the legal heirs of the respondent number 1 to the learned counsel for the appellant during the course of the day. List after 3 weeks.
Copy of this is I nagi problem. Copy of the I have not received a copy of it.
IA? IA is not listed today.
Main appendix.
Appeal. Mr. Kolita submits that he has not been furnished with a copy of the memo of appeal. Ms. Borthakur undertakes to furnish a copy of the memo of appeal to Mr. Kolita during the course of the day.
Yes.
Authorized.
Again, 26.
Made children. My lord collected. Also. My lord, here in this case, my lord, it is started from 10/3/2025. So my lord, times and again, they have taken time to file objection against my limitation petition. But that is not materialized, my lord. Again, my learned friend today saying, requesting me that time will be taken. So my lord, actually, it is a monetary matter, my lord, more than 1 year for filing a very short objection if they want to. But it is times and again taken, it is not filed, my lord. For more than 1 year.
Yeah, so who is appearing for the respondent?
Which will finally pass for the matter for the timing my senior is another
Who will appear?
RDB.
R?
RDB. CZC. Respondent number 2.
The objection was not filed. Okay, Mr. Sheikh, after some time,
My
let her senior come.
lord, it may be taken at 2, my lord, otherwise sometimes it is
We
difficult.
may not have.
My lord.
Before 2 p.m. our matters will over.
Obliged.
27.
After some time.
27.
27, same, my lord. Same thing.
Okay.
Please, your lordship.
Mm.
The respondent number 1, 2, 1, 2 has appeared, my lord. 2 and 3.
The one is the legal version of the 2-3. They both are the 2-3 is now attend the majority. So it is one is not necessary to be.
This today this IA is listed
Listed for condoning delay, my lord.
for
Delay of, my lord, 178 days, my lord.
Kobe, how many IAs are there?
Addition plus 1. Right. One is wasted, one is for condonation.
The total condonation, the 50%.
My lord, I have a prayer, my lord, if they do not object, my lord, because out of this same incident, my lord, there are 3 appeals filed by us along with the respondent number 6 in this IA, my lord. That application is fixed on 15/7 because the respondent number 6 had not received the copy, my lord. And in that case, I am the respondent. There are 2 appeals filed by 2 insurance companies, my lord. Those cases may come together, my lord. Okay, then, sir.
You are appearing for respondent number
2 and 3, your lordship.
2 and 3. Not for 1.
No. Your Honor, no, one is a legal version of.
One was the
2 and
appointed legal guardian, according to her, my lord.
Yeah.
But they were minor at the time of filing the application, my lord. Now they have attained majority.
majority,
So what is your contention now?
Yeah,
Do you have any objection in this application?
no,
No.
no, yeah.
And you are for respondent number 4, 5, and 6.
Opposite party number 6, orientation.
6. Who is for 4 and 5?
They have not appeared, madam. They have not appeared.
No, one council has filed Ugalandama.
Let me show. Mr. Ashton.
Mr. Sohan. এবার মাতি দিব পাৰি। After some time.
May I please, your lordship, I have filed the IA of 50%, releasing of 50% lordship. And payment is already deposited registry. But lordship, the no direction releasing the amount lordship. Kindly see the in my IA page number 12 lordship in order lordship.
Lordship, in the last order, it was ordered that it should be lifted before the appropriate bench, Lordship. And the service is also not complete because
Who is the appropriate bench?
Honorable Mrs. Justice Sushmita
Susmita.
Kauri. And the service is not complete, Lordship.
And lordship, in connection with, I have filed a close objection in item number 44 in supplementary list lordship.
It was a part-third matter.
Actually, that's why Lordship, even the NCR has come, it kindly heard. Arthur, no, because
Not part of
Arthur in the sense it was a pay and recovery, so Lordship said, that's why Lordship Honorable Mrs. Justice Dali Thakuria thought it appropriate to list it before the appropriate bench. That's why. It was heard by Honorable Mrs. Justice Sushmita Kauri.
Okay, then let it be before that bench.
Okay.
Uh,
And service is also not complete.
Heard, Mr. You
KK Das lordship.
learned counsel for the applicant and Ms. R.D. Mazumdar for the respondent opposite party number
1.
1. You,
3.
respondent number 3. In view of the order dated 6/1/2026, registry shall list the matter before appropriate bench.
And in the appeal, Lordship, the registry may write about the service, Lordship.
That court will consider.
And lordship, lordship, I have filed the pro subjection in item number 44 in connection. Yes, yes, lordship.
Supplementary items.
Voter link matter.
Yes, lordship. Notice me.
Please, please,
Notice.
I think, Lordship, in this way.
In view of the order,
Notice me.
same I number. I think it was I number. It was
I number 3.
3617. Registry shall list this. List this. CO means correct. Registry shall list this cross objection before the appropriate bench.
Item 30.
We got to know the matter today morning only. Our names in the court list will not show.
Now, what is your submission?
So we can take some time, sir. That's it.
In fact, my lord, office note says that service report has not been received from respondent 4. They have appeared, my lord. So far, service is complete. Only they can take time for 2 weeks, my lord, whatever they want to do. Service is complete.
Okay. Heard Mr. Buragomai, learned counsel for the applicant. And Mr.
And Sharma.
Learned counsel for the respondent. Opposite party. Mr. Buragomai submits that service in this matter has been completed. And as requested by Mr. So learned counsel for the respondent, registrar shall list the matter after a week. After a week,
Mind.
recusal is the matter after a week.
Obliged.
This is your lordship. As per office note 13/3/26, we have not taken steps, lordship, but we have taken step on 16/3/26. So lordship, the registry may verify the steps and
Okay.
give a.
Heard Ms. R.D. Mazumdar, learned counsel for the appellant. Ms. Mazumdar submits that she has taken step
On
upon the
16/3/2026.
upon the respondents on 16/3/2026. And in that view of the matter, she submits that the registry may be directed to track the postal consignment and to put up one up-to-date office note.
And a reminder for LCR may be sent, lordship. It has not been received as per office note.
And accordingly, it is provided that registry shall track the consignment and put up one up-to-date office note. The office note dated 13/3/2026 indicates that LCR has not yet been received. Registry shall issue urgent reminder to the learned tribunal for transmitting the record. List after 4 weeks.
Yes, highly obliged, lordship.
22.
Lordship, as for office note dated 25. 32. Lordship,
You are appearing for the respondent
I filed for now, madam, they have given for the
today.
today.
Heard Mr. A.J. Soikia, learned counsel for the applicant. And Mr. A.K. Azad, learned counsel for the respondent opposite party. This application is for delay condemnation. Any objection, Mr. Azad?
Difficult to say when today we will file Bharat Madam.
Pardon?
Today we will file Bharat Madam. After filing Bharat Madam, I will file objection, madam.
You will file objection.
Madam.
Mr. Azad submits that he may be granted some time to file objection. Where allowed, recusal is the matter. After a week,
Item 33.
Can I please, your lordship? This application is for striking out opposite party number 2, as they have already paid the enhanced amount, that is 90,000. And but the learned MSCT Sonitpur is not releasing the money. So in direction may be given so that we can withdraw the amount and the case will continue against opposite party number 5.
this interlocutory application is filed for
Striking out opposite party number 2.
respondent number 2,
Yes,
New India Assurance Company.
yes.
Where is the order dated 1st of December 2025?
Lordship, page 25.
25. Any objection? You were for
Respondent number 5.
respondent number 5 and respondent number 2. So your name has to be struck off from this array of this application, array of the MSc appeal. Heard Miss,
S. Chanda.
learned counsel for the applicant. And Miss Bihani for respondent number 5.
Yes, sir.
And Mr. Air, learned counsel for the respondent number 2. This application under order 1, rule 10, within bracket 2 of the Code of Civil Procedure is prepared by the applicant for amendment. No, for striking out the name of opposite party number 2, the New India Assurance Company Limited. As per order of this court dated 1st of December 2025 from the array of the MSc Appeal number 795 of 2018. The learned counsel for the applicant submits that in view of the order passed by a coordinate bench of this court on 1st of December 2025 in MSc Appeal number 795 of 2019, the name of respondent number 2, respondent opposite party number 2 is required to be struck out from the array of the MSc Appeal. The learned counsel appearing for the respondent number 2 and 5 submits that they have no objection. But accordingly, taking note of the submission of learned counsel for both the parties, this interlocutory application stands allowed. The name of respondent number 2 be struck off from the array of the MSc Appeal number 795 of 2018. And in view of the order passed in this interlocutory application, the learned counsel for the appellant shall file amended cause title in the MSc Appeal number so and so within a period of 1 week from today.
Lordship, any direction to the MSc Sonitpur so that we can withdraw the amount? They are not releasing without the permission of the honorable court.
So whether that appeal was admitted, MSc Appeal,
Yes, it was admitted.
you have filed any application there in
No.
that appeal?
We have shown them the copy. This one dated 1/12/2025.
Whether any amount was deposited before
Yes,
the
yes,
tribunal?
yes. 90,000 has been deposited.
No, you see, madam, today this IA is listed. In this IA, we cannot pass that order. We have to pass that order in the main appeal. So when it is listed. 6 weeks. So you file the amended cause title. When the matter will be listed before the court, then that order will be passed in that IA. No, in the main case.
Main appeal. Okay, all right.
34.
May I please?
Hmm.
This I is filed for specific direction.
For
IA is listed before the lawsuit.
IA for
IA for a specific direction to the applicant for withdraw the awarded
50%.
money, my lord. 50% awarded
Yes.
money with
Any objection? Heard Mr. Azad, learned counsel for the applicant, and Mr. Bhatt for the respondent opposite party number.
And for the appelling opposite party.
In this IA.
Opposite party number 1.
Opposite party number, but you are for Bajaj Alliance.
insurance. Insurance.
Appellant insurance company, see? In
IA is opposite party number 1, my lord.
And you for
Opposite party number 2 and 3.
respondent opposite party number 2 and 3. This interlocutory application under section 151 of the Code of Civil Procedure is prepared by the applicant for releasing, now for directing the registry to release 50% of the awarded amount deposited before the registry of this court. In view of the order dated 1st of August 2025, passed in IA number 2405 of 2025, in MSc Appeal number 313 of 2025. The learned counsel for the applicant submits that person to order being passed by this court on 1/8/2025 in IA civil number 2405 of 2025. The respondent opposite party number 1 has deposited 50% of the awarded amount before the registry of this court. And the applicants are willing to withdraw the said amount from the registry of this court, and therefore he has contended to issue direction to the registry to release the said amount in favor of the applicant. The learned counsel for the respondent opposite party submits that they have no objection. Accordingly, taking note of the submission of learned counsel for both the parties, this interlocutory application stands allowed. The registry is directed to release 50% of the awarded amount in favor of the applicant on proper identification. In terms of this IAS and disclosure. Part, Mr. Bhatt, learned counsel for the appellant. Mr. Azad for the respondent number 1. Respondent number 1 and Ms. So-and-so for the respondent number 2 and 3. Office note dated 16/5/2026 indicates that service in this matter has been completed and the LCR has been received. And in that view of the matter, the registry may be directed to list the matter for hearing. Accordingly, it is provided that registry shall list this appeal for hearing in usual course.
We have 35.
Wait, please, your lordship. Lordship, this is a delay conviction petition. This delay of 27 days.
Heard, Miss?
R does.
Learned counsel for the applicant. This interlocutory application is preferred by the applicant under proviso to section 173 of the MBA related to section 5 of the Limitation Act for condonation of delay of 27 days and preferring connected appeal. Challenging the judgment and award dated 21st of January 2026, passed by the learned member Motor Accident Claim Tribunal number 3, Kamrup M. Gauhati, in MSC number 1316 of 2019. Let notice be issued to the respondent opposite parties returnable in 4 weeks that be taken by speed post and also by usual process within a week from today. List after 4 weeks.
Obliged.
36.
My lord, limitation is barred by 64 days, it is for the first time, my lord.
Okay. Heard, Ms. L. Sharma, learned counsel for the applicant. This interlocutory application under section 5 of the Limitation Act is prepared for condonation of delay of 64 days in filing connected appeal against the judgment and award dated 3/11/2025, passed by the learned member Motor Accident Claim Tribunal, Kasar, Silsor in MSC case number 702 of 2020. Let notice be issued to the respondents opposite party returnable in 4 weeks. Step be taken by speed post and also by usual process within a week from today. List after 4 weeks.
Obliged, my lord.
37.
My lord, this is, I am, my lord, 48 days delay, my lord. 48 days delay, my lord.
Heard, Mr. S.S.
Triple S Rahman.
Triple S. Rahman, learned counsel for the applicant. This interlocutory application is prepared by the applicant under section 17 of the Railway Claims Tribunal Act 1987 for condonation of delay of 48 days in preferring miscellaneous first appeal against the judgment and order dated 31st of December 2025, passed by the learned Railway Claims Tribunal, Gauhati bench in AOI IU-10 of 2025. Let notice be issued to the respondents opposite parties returnable in 4 weeks. So you have added the member as a respondent number 2.
My lord.
Is it necessary?
No, no.
Then why you have added her?
My lord, from my lord. No, we'll delete it, my lord.
equal to returnable. False. A perusal of the interlocutory application reveals that the learned member technical railway claims tribunal Gauhati bench has been arrived as respondent number 2 hearing. Mr. Rahman submits that he may be allowed to strike off the name of the respondent number 2 from the array of this application. They are allowed at the cost and risks of the applicant, the name of respondent number 2 be struck off from the array of this application. In view of the order passed today in this application, Mr. Rahman, learned counsel for the applicant, shall file amended cost title within a period of 1 week from today.
Item 38.
There is delay of 21 days, my lord. It is for the first.
Amended. Yeah, dota asa. Live. Amended live. Ito katilin na ako. Yes, madam.
There is delay of 21 days. It is for the first time, my lord.
Art Ms. L. Sarma, learned counsel for the applicant. This application under Section 5 of the Limitation Act is preferred by the applicant for condonation of delay of 21 days and preferring appeal against the judgment and award dated
31/12/25.
31st of December 2025, passed by the learned member, Motor Accident Claim Tribunal,
Gwalpara.
Gwalpara, in MSC case number
53
53 of 2018. Let notice be issued to the respondent opposite party returnable in for its step be taken by speed post and also by usual process within a week from today. Madam, you have not drafted the application properly.
Yes, my lord. I have seen so.
In cost title, we have not mentioned the case number.
Oh, please.
39.
May I please, your lordship? My lord, here in this case, my lord, I am the owner, my lord. And my lord, the insurance company is directed to recovery 50% of the awarded amount. My lord, IA has been filed, my lord, there is some delay, my lord, in preparing the
Okay.
MSC appeal. At this stage, my lord, notice may go, my lord.
Heard Mr. A. Monaf, learned counsel for the applicant. This interlocutory application is preferred by the applicant for condonation of delay of 527 days in preferring connected appeal against the judgment
Judgment dated, my lord, 29/6/2024. Page,
where you have mentioned it.
my lord, page 27, my lord.
Is it not necessary to mention in the cost title of the application?
My lord, I have. My lord, your lordship kindly see, my lord, page 4, my lord, I have stated, my lord. And page 6 also, my lord.
Against the judgment and award dated
29/6.
29
6, 2024.
29/6/2024. Passed by the learned member, Motor Accident Claim Tribunal, Dhuburi, under section 166 of the Motor Vehicle Act. Let notice be issued to the respondent opposite party returnable in forex. Step be taken by speed post and also by usual process within a week from today. List of the forex.
Item 40.
Obliged, my lord.
I for the condonation of delay, there was 21 days delay in filing the appeal.
Parga ito. 4 weeks.
41,
23 days delay.
41.
23 days delay.
Coming again, 28.
Lordship, in this case, I am appearing for respond number 4 and 5.
Hmm.
Owner and driver.
So any objection in condonation of delay?
No, Lordship.
No. Heard Mr. D. Colita, learned counsel for the applicant. And Mr. Your name, please?
P. Mojumdar.
P. Mozumdar, learned counsel for the respondent number 4 and 5.
4 and 5.
And Miss? For 2 and 3, and you for?
6.
OP number 6. This interlocutory application under section 5 of the Limitation Act is read with section 173 of the MB Act is preferred by the applicant for condonation of delay of 178 days in preparing connected MSc appeal against the judgment and award dated 5/7/2026 passed by the learned member Motor Accident Claim Tribunal Bongaigaon in MSc case number 88 of 2016. The Kolita learned counsel for the applicant submits that the judgment and award dated 5/7. No, and the learned tribunal has passed the judgment and award on 5/7/2024. And thereafter, what is the reason?
My lord, the reason is explained in 3, 4, 5, my lord. Basically, my lord, after obtaining the copy of the judgment, my lord, it was furnished to Divisional Office Bongaigaon, my lord, on 11/9/24. Thereafter, my lord, the physical file was transmitted to Gauhati Regional Office, my lord. And Regional Office is the competent authority to take decision for filing the appeal, my lord. So in the meantime, my lord, uh, 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 some time was consumed, my lord, in between, my lord. That is why the delay occurred. my
Okay,
lord.
Mr. Kolita, learned counsel for the applicant referring to paragraph number 3, 4, and 5 submits that having obtained the certified copy of the impugned judgment dated 5/7/2024, the same was transmitted to the Divisional Office Bongaigaon and thereafter to the office at Gauhati, and in the process it consumed some time and the same was not intentional and has sufficiently been explained in the paragraph number 3, 4, and 5, and therefore he has contented to allow this application. Any objection on your behalf?
No.
No. You want to file objection?
Yes, ma'am.
The judgment has been apportioned between the OP number 6 and the insurance company, my lord. So that, my lord, objection, my lord. Maybe lordship, they will file objection. Otherwise,
Is
the
it
liability has
necessary?
been
We will hear the appeal.
apportioned, my lord. Lordship may kindly see, my lord.
My lord, the delay of 178 days.
Yes.
We will be filing the objection.
Okay. Okay.
Okay, ma'am.
And then, এইখিনি কাটি দিব লাগিব। The learned counsel for the respondent number 6, however, submits that the respondent number 6 will file objection petition and she prays for granting her some time. They are allowed. List the matter after 1 week or 2 weeks.
Lordship,
Is fixed in 15 July. Your
on
Honor.
15/7, my lord. 15/7, my lord.
Matter, Your Honor.
15 July.
15 July.
No, this is that is condonation of delay.
Yes, my lord. Yes,
Okay.
my lord.
Same.
Highly obliged.
And for admission, item number 3.
None appears for the appellant on call. It appears from the record that earlier on 2 occasions, that is on 7/2/2025 and 6/12/2024, this matter was listed before the court, and on both the occasions, the appellant remained unrepresented. Today also, the appellant remain unrepresented in that way of the matter. This court find no just ground to adjourn the case to another date, and accordingly the same is dismissed for non-prosecution.
Item number 6.
Wait, please, Your Lordship. My lord, this is an appeal under the Indian Succession Act. Appeal under Section 299 of the Indian Succession Act. We had filed for revocation of a probate that has been dismissed.
But Mr. Decker, learned counsel for the applicant. This I is for?
I is for stay.
This appeal under section 299 of the Indian Succession Act 1925 is directed against the judgment and order dated 12/2/2026. Passed by the learned additional district judge Dibrugarh in Mijje case number 4 of 2019, arising out of Miss Forbet case number 63 of 2001.
2001.
What is the memo of appeal? The grounds mentioned therein. Then also peruse the judgment and order dated 12/2/2026. Passed by the learned additional district judge Dibrugarh in Mijje case number 4 of 2019, arising out of Miss Forbet case number 63 of 2001. Admit. Issue notice to the respondents returnable in 4 weeks. Step be taken by speed post and also by usual process within a week from today. List after 4 weeks. Recess shall call for the record from the learned court below. Heard, Mr. Decker, learned counsel for the applicant. This application under order 41, rule 5, read section 151 of the Code of Civil Procedure is preferred by the applicant for staying the impugned order dated 12/2/2026 and for suspension of the operation of the probate certificate number 7/8/2018 in Mijje case number 4 of 2019, arising out of Miss Probate case number 63 of 2001. What is the application and the documents placed on record? So is there any urgency in staying the operation of the
My
impeachment?
lord, only difficulty is that we already obtained the probate, my lord. Initially, during the pendency of the revocation proceedings, there was a stay operating not to act on behalf on the basis of that probate, my lord. Now with the dismissal, that order has gone. Probate was issued, my lord. We filed revocation. It was stayed initially, but with the dismissal of the revocation, the probate has revived.
Mr. Deca, learned counsel for the applicant, submits that there is a requirement of staying operation of the impugned order dated so and so as the during the pendency of the petition on the Mistake case number 4 of 2019. The probate granted earlier was stayed.
Yes.
And after dismissal of the said Mistake case, the earlier order stands revived. And as such, there is a requirement of staying operation of the impugned judgment dated 12/6/2026. Accordingly, taking note of the submission of Mr. Deca, learned counsel for the applicant, the impugned order dated 12/2/2026 stands state till returnable date list after 4 weeks.
Well, it will not suspend the operation of the probate. Because this will not help me actually.
No, your pair is to stay the operation.
Of the, as well as the probate certificate, my lord, which was originally granted in Misdemeanor case number 63 of 2001.
Okay, along with operation of the probate certificate dated 7/8/2018, granted in favor of the respondent number 1.
Obliged.
Item 7.
May I please your lordship, by filing this appeal, challenging the order, my lord. Order dated 23 as by the learned district judge Bangaigaon in TSD. Now court to 20 dismissing the suit and stated not in related to an appeal. My lord, telling the order, my lord, on the ground, after filing this suit, my lord, this suit is not appreciated by the learned court, my lord, on the ground of my cruelty and adultery done by the respondent, my lord. One. PWD 1, under explaining my PWD 1, and my lord, on the ground, opposite ground, my lord. My lord. My lord, the brief was that the petitioner got married with the respondent in the year 1903. As per Hindu rites and after solemnity of marriage, both the parties were living at Chungapota near Kalimundi, PS, Kalimundi district, Bongaigaon, Assam, since the year 2015. Both the parties and respondent have been living severally same residential complex. So much incidents has been, so much cruelty has been done by the respondent to the petitioner, my lord. They have son or age of.
Okay. Heard Mr. Das, learned counsel for the appellant. This appeal under Section 28 of the Hindu Marriage Act 1955 is directed against the judgment and order dated 28/3/2026 passed by the learned district judge Bongaigaon in PS, D number 4 of 2020. Is to be noted here that by the impugned judgment and order dated so and so, the learned district judge Bongaigaon has dismissed the suit filed by the appellant herein, seeking divorce from the respondent wife. Where is the memo of appeal? and the grounds mentioned therein, and also peruse the impugned judgment and order dated 28/3/2026. Admit, issue notice to the respondent, returnable in 4 weeks. Step be taken by speed post and also by usual process within a week from today. This is still call for the record from the learned court below. Place the matter after 4 weeks.
Rules, my lord.
In this case, Lordship, I am hearing for respondent number 2. We were supposed to file objection, Lordship, is ready but not filed, Lordship. Otherwise, Lordship, order delay over this case, Lordship.
Pardon?
There is a delay of 731.
No, therefore this IA is filed.
Yes, Lordship.
You want to file objection?
Yes, Lordship, it is already ready, Lordship, but it is not filed. I filed, Lordship, in a day, 2 days, Lordship.
How many adjournments you have already availed?
Already taken number 7.
How many?
Okay.
Hmm.
And also, Lordship, order is there
Mhm.
against condemnation of delay without any sufficient explanation of the delay.
No, if you want to file objection, all right, you file it.
It may be in the first week of June, Lordship.
First week of June.
Lordship. In the meantime, I file.
My lord, my prayer will be before your lordship. That should be the last chance. Otherwise, it
Okay.
will not come. The date may
Heard,
be fixed.
Mr. MSEC, learned counsel for the applicant, Ms. R. Devi for respondent number 4.
Second, Lordship, respondent 2.
Respondent number 2, you for?
NFL.
Respondent number 1, and you?
For state government, Lordship. State of.
Ms. Devi submits that she may be granted another opportunity to file objection. Mr. Sheikh, learned counsel for the applicant, however, submits that the respondents have availed several opportunity for filing the objection petition. And as such, last opportunity may be granted to the respondents to file their objection. They are allowed. Rest is unless the matter on COVID weeks. Well, last June.
10 June.
10 to
Sorted
5th June.
5th of June. It is being clarified that no further opportunity will be afforded to the respondents to file their objection.
Oblige, lordship. 27 is similar.
27.
Similar one.
Same, okay.
Oblige, lordship.
Okay.
8.
This is an appeal for enhancement, lordship. British at TCR may call.
Enhancement.
Enhancement.
Heard Mr. M. Khan, learned counsel for the appellant. This appeal under section 173 of the MB Act is directed against the judgment and award dated 18/2/2026 passed by the learned member, Motor Accident Claim Tribunal, North Salmara, Abhayapuri. Bowing out in MSC case number 91 of 2023. There is the memo of appeal, the grounds mentioned therein, and also the impugned judgment and award dated 18/2/2026 passed in MSC case number 91 of 2023. Admit, issue notice to the respondents returnable in 4 weeks. Step be taken by speed post and also by usual process within a week from today. Rest shall call for the record from the learned tribunal. List the matter after 4 weeks.
This is prepared for enhancement, lordship.
Enhancement. Heard Mr. ABT Hawk, learned counsel for the appellant. Is appeal under section 173 of the Act is directed against the judgment and award dated 13/3/2026 passed by the learned member motor accident claim tribunal Sribhumi in MSC case number 13, which will make a date of 2023. Peruse the memo of appeal, the grounds mentioned therein, and also peruse the impugned judgment and award dated so and so so and so. Admit issue notice to the respondents returnable in 4 weeks. Step be taken by speed post and also by usual process within a week from today. Recessal all for the record from the learned tribunal. Place the matter after 4 weeks.
This is also for elsewhere.
Order is right. 4 weeks.
11.
But the statutory appeal lawsuit challenging the quantum of compensation lawsuit. The case of a minor lawsuit, monthly income was taken as 11,500 in the higher side.
Is the Azad Eva for respondent number? Oh no, sorry. Yes. Eva for respondent number? 1. Respondent number 1.
I filed the whole of the matter yesterday.
Yesterday.
And the other person.
And?
And then nothing.
Nothing
But
reflected.
receipt number 26.
Third, Mr. is a Sokia, learned counsel for the appellant, and Mr. Devnath,
Yes, and then
learned counsel for the respondent number 1. This appeal under section 173 of the NBAC is directed against the judgment and award dated 7/2/2026 passed by the learned member motor accident claim tribunal number 3, Kamarpam, Gauhati, in MSC case number 1176 of 2019. Peruse the memo of appeal and the grounds mentioned therein, and also the impugned judgment and award dated 7/2/2026. Admit issue notice to the respondents returnable in 4 weeks. However, no formal notice is required to be issued to the respondent number 1 since Mr. Devnath entered appearance and received notice. However, extra requisite copy of the memo of appeal be furnished to him during the course of the day. Step upon respondent number 2 and 3 be taken by speed post and also by usual process within a week from today. Recessal call for the record from the learned tribunal. List the matter after 4 weeks. IA for
Stay lawsuit.
Third, Mr. Soitia, learned counsel for the applicant, and Mr. So-and-so, learned counsel for the respondent opposite party number 1. This application under order 41 rule 5, read with section 151 of the Code of Civil Procedure, is prepared by the applicant for staying operation of the impugned judgment and order dated 7/2/2026, passed by the learned member motor accident claim tribunal number 3, Kamrup M. Assam in MSC case number 1176 of 2019. Mr. Soikia submits that the connected appeal has already been admitted for hearing and the record has also been called for. Then as such, there is a requirement of staying operation of the impugned judgment and award dated 7/2/2026. Any objection?
no, honestly, I have no objection. Matter 50% maybe it is to the claim.
The learned counsel for the opposite party number 1 submits that he has no objection, but the applicant may be directed to deposit 50% of the awarded amount before the registry of this court. Accordingly, taking note of the submission of learned counsel for both the parties, the impugned judgment and award dated 7/2/2026 stands state will returnable debt. No, no, till disposal of the MSC appeal number so and so. Subject, however, to depositing of 50% of the awarded amount before the registry of this court. In terms of above, this IA is then closed.
My fear is that 50% may be released to the claimant, my lord, because
The learned
more than
counsel
the medical bill was there in the minister to the
for the respondent number 1, however, submits that the respondent number 1. Who are the beneficiaries?
mother of the disease, my lord. She was 11 years old, 3 months indoor patient, 9 lakhs bill was there, my lord. The learned tribunal accept the 7,30,639 as a medical expenditure.
No.
My lord, at least 50.
Apart from opposite party number 1,
Yes.
how many beneficiaries are there?
Father of the disease.
Mother of the disease.
She was Hafiza Begum was the mother of the disease, my lord.
Mm.
So the 11
So
years
she will also entitled to some of the amount.
father.
Yes.
No, in my lord, in claim petition, we have made only mother of the disease. Only, yes, your lordship, you go through the judgment also, only mother of the disease. Mother was also injured and she got this entire amount that was also disposed of.
Oh, she has received the amount.
Yes, in her injury case, lordship. That's the
Okay.
case, one injury
Okay.
case, mother
Okay.
injured and she died. Well, in that case. Kindly, it is 2009, my lord. And the medical bill also.
Okay. On such amount being deposited before the registry of this court, the respondent opposite party number 1 be allowed to withdraw the same on proper identification and verification of relevant documents.
Item 12.
This appeal is basically filed. Lordship will kindly see one thing. Disease was traveling in a motorcycle, belongs to his own brother, and that is a third-party policy. And third-party policy occupant is not covered. Lordship will kindly see page 11 of the judgment.
Mm.
Lordship got it.
Mm.
Lordship will find claimant Kobita Das, 21 years, and Mosami Das. All are, Lordship, the claimant number 4, Reba Das, wife of Sudhir Ranjan Das. Lordship got it.
Mm.
Now, Lordship, respondent Haru Das, son of Sudhir Ranjan Das. Same family, same brothers. And vehicle is of third-party risk. Page 29. Page 29, para 37. Page 29, para 37. Lordship got it?
Mm.
I have carefully gone through the Exhibit A insurance policy, which shows that insurance policy covered own damage with effect from man. Where the personal accident, third-party liability remains on 19/8/2019. Premium for third party has also been taken from the insured. The third party insurance policy, date of accident is 26/8/2020. There is no coverage.
Heard. Mr. Goswami, learned counsel for the appellant. This appeal under section 173 of the MB Act is directed against the impugn judgment and award dated 5/2/2026 passed by the learned member, Motor Accident Claim Tribunal, Kasar Silsor, in MSC case number 601 of 2020. There is the memo of appeal, the grounds mentioned therein, and also there is the impugn judgment and award dated 5/2/2026 passed in MSC case number 601 of 2020. Admit issue notice to the respondents returnable in forex that be taken by speed post and also by usual process within a week from today. Yes, shall call for the record from the learned tribunal is the matter of the forex.
Lordship, notice on respondent number 2 and 3, Lordship, we will serve on 1 because 2 and 3 are minor. Respondent number 2 and 3 are minor.
Mr. Goswami also submits that respondent number 2 and 3 are minor.
So we'll
and-
start notice on respondent number 1.
So, the appellant may be allowed to effect service upon the respondent number 1.
1 only.
They are allowed. Heard, Mr. Goswami, learned counsel for the applicant. This application under order 41. Rule on this application is preferred by the applicant for staying operation of the impugn judgment and award dated 5/2/2026 passed by the learned member, Motor Accident Claim Tribunal, Kasar Silsor, in MSC case number 601 of 2020. Mr. Goswami, learned counsel for the applicant, submits that connected appeal has already been admitted for hearing and the record has been called for. And as such, there is a requirement for staying the operation of the impugn judgment and award dated 5/2/2026. Till disposal of the MSC appeal. Where, it appears that the MSC appeal has already been admitted for hearing and the record has been called for. And in that view of the matter, the impugn judgment and award dated 5/2/2026 is state till returnable debt. Till disposal of the MSC appeal, number so and so, subject however to depositing of the 50% of the awarded amount before the registry of this court within a period of.
May I submit one thing, Lordship? We have no liability under the policy. If we deposit, Lordship, we have no liability under the policy.
Maybe you deposit the amount, but we will not release it.
Otherwise, they will come for a release of the amount, Lordship.
Maybe you file objection then. We'll consider
Lordship,
your claim.
Lordship may object that it should not be released, Lordship.
Pardon?
I will deposit, Lordship, but it should not be released.
No,
Lordship.
no, the question of releasing does not arise because the other party is not before this court. Let it be, but you remind it whenever the matter is listed.
No, otherwise, Lordship, may I submit one thing, Lordship? Generally, Lordship, the appellant company will ask why we have no liability and you are agree for deposit.
No, no, we have not decided whether you have liability or not at
not.
this stage.
Lordship.
So let it be remain as such. You deposit the amount, but we will not release it. Within a period of 2 months.
It should be a fixed deposit, Lordship. It should be made fixed deposit by the registry. Kept in fixed deposit. Otherwise, interest will be lost. Registry will make it fixed deposit also. Amount.
No, whether
It will benefit everyone. No, if Lordship decided otherwise, also it will benefit the claimant. If Lordship decide otherwise, also that claimant will entitle, then also claimant will get the interest. And it is
no, whether any such order was passed earlier.
Lordship. Many occasions it was directed because territory amount also directed to be deposited with interest, released with interest. That is why Lordship, the amount deposited by the insurance company will be kept fixed deposit till disposal. It will benefit both the account, Lordship. It will benefit the claimant also. Otherwise, he will also.
Otherwise, also the matter will be the amount will be in the bank.
Bank, no interest. Current account.
It will be accrued in that account against that account.
It is a current account.
Maybe.
Current account, no interest.
No interest.
No interest.
Okay. Mr. Goswami submits that the amount may be kept in fixed deposit as it will benefit both the parties. Fair and not rescission to done it.
Item 13.
সই করার আগতে মোক জনাব।
May I please, your lordship?
Yes.
My lord, this is an appeal, my lord. This is against quantum, my lord. My lord, because basically the ground is, my lord, the death of a 7 years old, my lord, minor boy, my lord. And the award is, my lord, 22 lakhs, my lord. For a death of a minor of age at 7 years, my lord.
Heard, Mr. Colita, learned counsel for the appellant. This appeal under section 173 of the MB Act is directed against the judgment and order dated 25/2/2026. Passed by the learned member, Motor Accident Claim Tribunal number 3, Kamrup M. Gauhati in MSC case number 2464 of 2023. Peruse the memo of appeal and the grounds mentioned therein. Then also peruse the impugned judgment and award dated so and so. Admit. Issue notice to the respondents, returnable inquiries that be taken by speed post and also by usual process within a week from today. Rest shall call for the record from the learned tribunal. Lays the matter after 4 weeks. I heard Mr. Colita, learned counsel for the applicant. This interlocutory application is preferred by the applicant under Order 41, Rule 5 of the Code of Civil Procedure for staying operation of the impugned judgment and award dated 25/2/2026. Passed by the learned member, Motor Accident Claim Tribunal number 3, Kamrup M. Gauhati in MSC case number 2464 of 2023. Mr. Colita submits that connected MSC appeal has already been admitted for hearing and the record has been called for, and as such, there is a requirement of staying operation of the impugned judgment and award dated 25/2/2026. And it appears that the appeal is admitted for hearing and the record has been called for. And as such, there is a requirement of staying operation of the impugned judgment and award dated 25/2/2026 till disposal of the MSC appeal number 264 of 2026. Accordingly, the impugned judgment and award dated so and so stands state till disposal of the MSC appeal number so and so, subject however to depositing of 50% of the awarded amount before the registry of this court within a period of 2 months from today, list after 4 weeks.
My lord, may I pray
Now,
for,
in terms of this IA stands disposal.
Lord, may I pray for deposit of 30%, my lord, because 22 lakhs is too high for a minor boy of 7 years, my lord.
Maybe we are not deciding the appeal on merit.
My lord,
Deposit the
I love
amount.
I disposed of
Even
my
if we release the amount, it will be adjusted against
my
the
lord, my lord,
final determination.
my lord, my lord. I disposed of my lord.
I dispose.
My highly appreciated.
My pleasure, my lord. Yeah, the insurance company has preferred this appeal lordship against the award passed by Lord MSC T. Kassar lordship. Here, 50% liability of the compensation award has been imposed upon the insurance company, holding the vehicle of the insurance company equally liable for the alleged accident lordship. But what happened lordship in this case, the charges has been filed against the other vehicle. And there's a clear admission of the owner driver of the said vehicle, other vehicle, that he was negligent in driving. And police record lordship shows that it was a sole negligence of the other vehicle. And there is no evidence on record to show that our vehicle was negligent while parking lots. There was no evidence adduced by the claimant that our vehicle was parked in a no parking zone or there is no,
Okay, we will hear you
Lordship,
on merit. Today we will admit the appeal.
Lordship.
Heard Mr. P.J. Burman, learned counsel for the appellant. This appeal under section 173 of the MB Act is directed against the judgment and award dated 16/3/2026 passed by the learned member, Motor Accident Claim Tribunal number. Claim Tribunal, Kasar Silsore in MSC case number 559 of 2019. Where is the memo of appeal and the grounds mentioned therein? And also where is the in judgment and award dated 16/3/2026. Admit, issue notice to the respondents returnable in 4 weeks. Step be taken by speed post and also by usual process within a week from today. Rest shall call for the record from the learned tribunal. Place the matter of 4 weeks. This IA,
I is for stay, Lordship.
uh,
But
subject
Lordship
to
here,
depositing 50% of
Lordship,
the
here,
awarded amount
here I want to
within a
place
period
before
of
Lordship that
2 months from
it
today.
may not be, Lordship, because this issue, Lordship, 50% deposit is now prejudiced, pending before larger bench of the Supreme Court, Lordship, because this issue is
No,
yet to be decided.
that issue has yet to
Yes.
be determined.
Yes, to be
So
decided.
you deposit the amount.
Lordship, 50%, then 50% of the 50%, our liability.
Pardon?
We are settled with the liability of 50% of the total amount.
Hmm.
So it will be 50% of the 50%. Yeah, our
Okay,
amount.
50% of the liability imposed upon the appellant.
Lordship, and it shall be released, shall not be released unless
No,
or
no,
until
no, no. That
court
observation,
passes an hour.
and,
Lordship.
it is premature to observe.
Yes, Lordship, yes, that's it.
The other party is not before this court. The question of releasing does not arise.
Lordship. Obliged.
It will ever.